Welcome to the sixth annual Lester Kissel Lecture. I'm Arthur Applebaum, Director of Undergraduate Fellowships at the Edmund J. Safra Center for Ethics. And on behalf of the center's director, Danielle Allen, I have the most pleasant task of introducing our speaker, Linda Greenhouse. But first, a few words about our dear Lester Kissel. Lester died in the year 2000 at the age of 98. He had been the managing director of Seward & Kissel, a major Wall Street law firm specializing in financial law. In his early 60s, he started reading Hindu ethics and asked himself, is this all there is to life? This being a lawyer for big banks. He began going to India, even had a guru, who taught him that reincarnation is real, and that with sufficient study and work, he might come back as a worthy soul. Kissel's long-standing interest in values in public and professional life led to his commitment to the beginning ethics initiative at Harvard, starting with early conversations and correspondence with President Derek Bok and later with President Neil Rudenstein and the center's founding director, Dennis Thompson. Lester would visit us in between his treks to India, and each time he would remind us, rather oracularly, to attend not only to ethics, but to values. And then he'd trot off again to India. In the fullness of time, Lester bequeathed to the Ethics Center a magnificent gift. The thought did occur to us that Lester might ask the Ethics Center to devote attention to the study of Hindu mysticism or even reincarnation. Nowadays, this wouldn't be all that unwelcome. Indeed, the Safra Center has partnered with the Berggruen Institute to study ethics from a cross-cultural perspective with an emphasis on Eastern philosophical traditions. In the 1990s, however, we had not yet attained such enlightenment. Our concern was unfounded because Lester was scrupulous about honoring a self-imposed establishment clause separating ashram and university. As the New York Times Supreme Court correspondent for 30 years, Linda Greenhouse has been our guide to the Establishment Clause and every other constitutional clause. I can't remember a time when she wasn't my best interpreter of the US Constitution. I did, however, miss out on the early Greenhouse, when in 1964, she was the only Radcliffe freshman to successfully comp the Harvard Crimson. At the Times, Ms. Greenhouse practiced a fearless form of reporting on the court that pushed against the rather spineless convention that journalistic objectivity, imagine scare quotes around that, required all statements of expertise to be quotations from some outside expert, and the completely supine convention that journalistic even-handedness required finding a quote from some other expert saying the opposite. After all, Ms. Greenhouse was herself the expert, delivering to her readers astute news stories and commentary on both constitutional law and judicial politics with penetrating lucidity and confidence. Her reporting won her the Pulitzer Prize and many other major awards and honors. After stepping down from the Times 10 years ago, though she continues to write a column twice a month that is not to be missed, Ms. Greenhouse joined the faculty of Yale Law School, where she is the Joseph Goldstein Lecturer in Law and the Knight Distinguished Journalist in Residence. This is a homecoming of sorts for her because she earned a master's degree at Yale Law School to prepare for her Supreme Court beat. Ms. Greenhouse is the author of a biography of Justice Harry Blackmun, a book on the abortion debate before Roe, a history of the Burger Court, a very short guide to the Supreme Court, that's the title of it, the Supreme Court, a very short guide, and most recently, a personally disarming but professionally and politically pointed memoir, Just a Journalist. I can't resist reading a short passage from that book, illuminating what a struggle it has been for the newspaper of record to stand behind the plain meaning of certain words. Earlier, Linda Greenhouse described the paper's plunge into using the T word, torture, and the L word, lie. Here she gives an example from her own reporting. In her 2007 wrap-up of the first term of the Roberts Court, she wrote, or attempted to write, "This was a conservative court." Now, Linda Greenhouse. I filed the story and, still at my desk sometime later, was approached by a rather sheepish Washington bureau chief. The executive editor had an objection, he told me. I couldn't say on my own authority, without the cover of a news analysis label, that it was, quote, a conservative court. At first, I didn't think I heard correctly. Then, as it sunk in, I decided that I can play this game too. Fine, I said, if the executive editor wants to change it, he can take my byline off the story. Withholding a byline is a rare and ultimate statement of protest by a journalist. Clearly, as I knew, this wouldn't fly for the lead of the Sunday paper. How about just calling it a news analysis? My increasingly desperate boss asked. No, I said, I am simply stating a fact. It is a conservative court. He went back to his desk for more consultation with New York. He came back to my desk. Suppose we said that it was a more conservative court. More than what? I asked. More than it was before, he answered. This seemed silly, but at the same time, a needless place to draw a line in the sand. Clearly, the bureau chief had worked out a face-saving compromise for the executive editor. Sure, I said, it's a more conservative court. This evening, we will hear more about the Roberts Court, as Ms. Greenhouse takes a critical look at cases such as Masterpiece Cakeshop, Hobby Lobby, and Little Sisters of the Poor, where the court has empowered individuals to opt out of general rules on the grounds of religious conscience. Perhaps, she will argue, without adequate regard for the burdens that these exemptions put on others. Please join me in welcoming Linda Greenhouse, whose lecture is entitled The Supreme Court's Threat to Civil Society.
Thank you, Arthur, and thank you for reading that passage, which makes me laugh. So I'm not sure I can live up to Mr. Kissel's love of mysticism. This is going to be a very grounded talk in reality. But it's great to be back at Harvard, have some old friends here in this audience, and thank you all for coming. So I'm going to begin by setting two texts side by side and inviting you to compare them. The first is a paragraph from Justice Potter Stewart's opinion for the court in a case called Abood against Detroit Board of Education. This was a labor case decided in 1977 by a vote of 9-0. The question in the case was whether the First Amendment right of free speech and association gave public employees who chose not to join a labor union the right to opt out of paying that portion of union dues that provided the union with the resources to fulfill its duty to represent and bargain on behalf of everyone in the bargaining unit, whether union members or not. In other words, at issue was the constitutionality of what was known as the agency fee system, under which nobody had to join the union, but all had to pay their fair share for the benefits that all received. The objecting employees argue that the system subjected them to an unconstitutional degree of, quote, ideological conformity. This is how Justice Stewart, writing for the court, analyzed the problem. It's kind of a long quote, but you'll get the drift of it. To compel employees financially to support their collective bargaining representative has an impact upon their First Amendment interests. An employee may very well have ideological objections to a wide variety of activities undertaken by the union in its role as exclusive representative. His moral or religious views about the desirability of abortion may not square with the union's policy in negotiating a medical benefits plan. One individual might disagree with the union policy of negotiating limits on the right to strike, believing that to be the road to serfdom for the working class, while another might have economic or political objections to unionism itself. An employee might object to the union's wage policy because it violates guidelines designed to limit inflation, or might object to the union seeking a clause in the collective bargaining agreement proscribing racial discrimination. The examples could be multiplied. To be required to help finance the union as a collective bargaining agent might well be thought, therefore, to interfere in some way with an employee's freedom to associate for the advancement of ideas, or to refrain from doing so as he sees fit. But Justice Stewart continued, such interference as exists is constitutionally justified by the legislative assessment of the important contribution of the union shop to the system of labor relations established by Congress. And here Justice Stewart quotes from Justice William O. Douglas in an earlier labor case. He says, The furtherance of the common cause leaves some leeway for the leadership of the group. As long as they act to promote the cause which justified bringing the group together, the individual cannot withdraw his financial support merely because he disagrees with the group's strategy. The furtherance of a common cause. Hold that thought, please, as I turn to my second text. And first, I'll give a bit of context. Last month, January, a federal district judge in Philadelphia granted an injunction barring enforcement of new rules issued by the Trump administration, exempting employers with religious or, quote, sincerely held moral objections to contraception from the requirement in the Affordable Care Act to provide birth control along with other preventive coverage in their employee health plans. The judge, Wendy Beetlestone, noted the, quote, remarkable breadth of these exemptions, which apply to for-profit as well as nonprofit businesses. She noted that Congress had considered and rejected a broad conscience opt-out from the birth control mandate. The new rules thus violated, she said, the plain command of the statutory text, and she observed that if enforced, the rules would cause thousands of women to lose insurance coverage to which they are legally entitled. And now to my text. The response of the press secretary of the Department of Health and Human Services to Judge Beetlestone's ruling. Quote, no American should be forced. That's exciting. Okay. Thank you. No American should be forced to violate his or her own conscience in order to abide by the laws and regulations governing our health care. No American should be forced to violate his or her own conscience in order to abide by the laws and regulations governing our health care, said Caitlin Oakley of the Department of HHS. The story I have to tell in this lecture inhabits the space between Justice Stewart's invocation of our common cause and Ms. Oakley's seemingly obliviousness to the welfare of thousands of American women who happen to work for bosses who object to birth control. I argue that these two texts stand as goalposts at either end of a playing field known as civil society. If the two appear asymmetrical, one a statement by the Supreme Court in a published opinion, and the other a remark by a federal bureaucrat in immediate response to breaking news, the asymmetry is likely to be only temporary. Judge Beetlestone's opinion after an initial appeal is highly likely to reach the Supreme Court, a court that only 4 years ago found itself unable, following the death of Justice Scalia, to decide the permissible scope of an accommodation to employers unwilling to abide by the birth control mandate. The shorthanded court's stalemate in that case, Zubik against Burwell, provided the gap that the Trump administration's broad exemptions now seek to fill. With the addition of new justices, Neil Gorsuch and Brett Kavanaugh, there's reason to expect that today's Supreme Court will be able to decide the question and to decide it in favor of the conscience opt-outs. And what would be the harm of that? The United States, after all, has a proud tradition of protecting minorities who assert claims of conscience against mainstream norms that would overwhelm or even crush unconventional practices and belief systems. If the political system has often failed to extend such protections, the courts have done so. Such Supreme Court decisions as Sherbert against Verner, which protected a Seventh-day Adventist from having to work on his Sabbath, and Wisconsin against Yoder, which exempted the Amish from having to send their children to high school, are well known to anyone with a passing familiarity with the history of the First Amendment's free exercise clause. These decisions are celebrated as symbols of American society's commitment to freedom of conscience, of the protection of conscience as an essential aspect of civil society. The Civil Rights Act of 1964 protects religious claimants from employment discrimination and requires employers to accommodate the needs of religiously observant employees as long as the accommodation will not impose undue hardship on the conduct of the employer's business. The conservative writer Ryan Anderson, in an argument against same-sex marriage, observed that, quote, religious liberty plays a crucial role in preserving civil society as something separate from government, unquote. Few of us would argue with that statement as an expression of abstract principle. But given recent developments in our politics and our law, We need urgently to move from the abstract to the concrete and to question whether conscience claims, as they're being expressed and honored today, rather than embodying the best of civil society, have become a threat to it. So with that introduction, I want to focus our attention on the Supreme Court and to begin on the most important decision of the court's last term. The most important decision, in my view, was not the failed challenge to the Trump Muslim travel ban. It was not the case on the rights of the Colorado baker who wouldn't bake a cake for a same-sex couple's wedding celebration, although I will return to that case. It was a labor case, Janus against American Federation of State, County, and Municipal Employees. The question in Janus was whether to overrule our old friend, Detroit Board of Education against Abood. To the surprise of absolutely no one, that is what the Supreme Court did. For reasons I will describe, the outcome, even the vote of 5-4, had been anticipated for years. The decision was highly anticipated by the time the case was decided last June 27th. It did not go unnoticed, but few people, I think, have fully comprehended just how radical this decision was and how much it tells us about the current Supreme Court. I began this talk with the rationale of Abood, Justice Stewart summoning us to our common cause, so that you would be in a position to understand fully the move that the court made in Janus. Janus is worth talking about from numerous angles: First Amendment doctrine, judicial behavior, practical impact. I'll discuss these in order to lay a foundation so that we can see the case as a whole before I get to the most important point, what the decision suggests about the Supreme Court's role in the fraying of the fabric of civil society. I'll begin briefly with the First Amendment. It's hard to be brief about the First Amendment, but I will try. From today's perspective, the mediated view of the First Amendment that the court expressed 42 years ago in Abood, that the First Amendment provides a framework for balancing the collective interests of the state against the interests of private speakers, seems to come to us from a different era. It was an era when the First Amendment served to enable free and open public discourse. An era before, for example, the Supreme Court ruled in the 2011 case of Sorrell against IMS Health that Vermont violated the First Amendment rights of pharmaceutical companies when it barred pharmacies from selling doctors' prescription records to them, records that enabled pharmaceutical salespeople to make targeted sales pitches to doctors for expensive new drugs for patients who were being treated with inexpensive old ones. It was an era before the DC Circuit ruled that tobacco companies have a First Amendment right not to be required by federal regulators implementing a 2009 Act of Congress to display on their packaging disturbing photographs of what happens to people who smoke, a decision the Obama administration decided would be counterproductive to appeal to the Supreme Court. And just last week, the U.S. Court of Appeals for the Ninth Circuit, relying on the Supreme Court's most recent First Amendment precedents, granted a preliminary injunction against enforcement of San Francisco's sugar-sweetened beverage warning ordinance, which requires soda advertisements to contain a warning that, quote, drinking beverages with added sugar contributes to obesity, diabetes, and tooth decay. The required warning also had to include the notice that this is a message from the city and county of San Francisco. Excuse me. Unsweetened water, right? There's little doubt that a few years ago, this public health measure requiring the inclusion of truthful information in a commercial advertisement would have been upheld. The Ninth Circuit's conclusion to the contrary was unanimous. In other words, Abood was the product of an era before the First Amendment was turned into a potent tool of deregulation, before it was, in the words of Justice Elena Kagan's dissenting opinion in Janus, weaponized. So when Justice Alito, writing for the majority in Janus, said that Abood had become, quote, an anomaly in our First Amendment jurisprudence, it was hard to argue with him. The shorthand for what Justice Stewart offered as the rationale for Abood came to be known as the free rider problem, the notion that peace in the workplace would be threatened by the presence of fellow workers who would not be paying their fair share. A series of decisions following Abood made clear that the fair share obligation extended only to the expenses of collective bargaining and representation, Employees could opt out of paying for the expenses connected with a union's political advocacy. Few question that distinction as a matter of law or policy. But the Janus majority found any such distinction unworkable as a means of solving what it viewed as the central problem of coerced speech. As Justice Alito explained, quote, "Petitioner strenuously objects to this free rider label. He argues that he is not a free rider on a bus headed for a destination that he wishes to reach, but is more like a person shanghaied for an unwanted voyage," unquote. The impact of Janus is considerable, extending well beyond the labor context. For instance, the court's analysis has invited litigation against mandatory bar dues and bar membership. The justices actually considered one such case this term, a challenge to mandatory bar membership in North Dakota. That case was filed before Janus, clearly in expectation of Janus's outcome. The justices took the case up in their private conference 8 times during this fall, before finally vacating the Eighth Circuit decision below, which had upheld the compulsory bar membership, and remanding the case to the appeals court for reconsideration in light of Janus. Well, the court's docket-setting function is notably opaque. It's clear from the many times that the justices are listed as having discussed this petition at their weekly private conference that the disposition was controversial inside the court. It's highly likely that some members of the court were eager to take up the bar dues case on the merits at this point, without waiting for the lower courts to decide how to apply Janus to related challenges. There will be other cases in the pipeline in short order. And of course, Janus will exact a substantial price from public employee unions, which under the legal duty of fair representation will have to continue doing their work on behalf of non-members and members alike, even as their dues revenue shrinks. It's no coincidence that public employee unions have been a target. Even as union membership in the private sector sinks almost to invisibility, standing now at 10%, union membership is actually quite robust in the public sector, where more than 1/3 of employees are union members. And further, public sector unions tend to skew progressive. They support Democrats. In the wake of Janus, there are lawsuits seeking to claw back agency fees that have already been paid. One such case was recently dismissed in the federal district court in Seattle. The judge declared that the union was entitled to a good faith defense since the dues were constitutional at the time the union collected them. But other cases are pending and may find friendlier judicial audiences. So what does Janus tell us about the Roberts Court? I think we can conclude without exaggeration that it tells us that no precedent is safe. Janus provides a roadmap for how to hollow out a precedent so completely that a baby's breath can deliver the final blow. And I can't emphasize enough the extent to which overturning Abood was Justice Samuel Alito's project. And here, in brief, is how he did it. The story is illuminating. It began in 2012 with a case called Knox against Service Employees International Union. The question was a very narrow one, how the union should have treated a special dues assessment and what accommodation it should have offered to objecting members of the bargaining unit. But Justice Alito, in a decision signed by 5 justices, went beyond the question presented to place Abood squarely in the court sights. He said, quote, "Our prior decisions approach, if they do not cross, the limit of what the First Amendment can tolerate." And he said in any future case, quote, "The general rule that individuals should not be compelled to subsidize private groups or private speech should prevail." This was, of course, an invitation to bring the court more cases. The next one arrived 2 years later, a case called Harris against Quinn. That produced another 5-4 decision with a majority opinion by Justice Alito. It held that Abood did not apply in the limited context of unionized home health workers due to an employer-employee relationship there that's very different from the relationship in a conventional workplace. Justice Alito went further. Abood was questionable from the very start, he wrote. The Abood court, quote, "failed to appreciate the conceptual difficulty," unquote, of the fact that in the public sector, both collective bargaining and political advocacy and lobbying are directed to the government. Quinn had been brought to the court by the National Right to Work Legal Defense Fund, which in its briefing asked the court directly to overrule Abood. That was not necessary, Justice Alito said, not necessary yet. Justice Kagan, in an opinion for the 4 dissenters, saw what lay ahead. There's no principal distinction between this case and Abood, she said, and therefore no need for the majority's extended discussion of Abood's supposed deficiencies. Quote, today's opinion takes the tack of throwing everything against the wall in the hope that something might stick, she said. It would stick soon enough. The following year, 2015, Friedrichs against California Teachers Association reached the Supreme Court. This was the first case since Justice Alito began his campaign that squarely presented the issue in a posture that gave the court a clear choice between reaffirming Abood or overturning it. The litigation was financed by the conservative Lindy and Harry Bradley Foundation through its grantee, the Center for Individual Rights. Bradley also financed, at least in part, 11 of the organizations that filed amicus briefs on the plaintiff's behalf at the Supreme Court. Friedrichs followed a very unusual path to the court. In federal district court in California, the plaintiffs did not contest the union's motion for summary judgment. Then, having lost in district court according to plan, the plaintiffs asked the Ninth Circuit to affirm their defeat. Obliging, as settled law required, the appeals court affirmed in a one-paragraph order, calling the case, quote, so insubstantial as not to require further argument, unquote. Despite the absence of a conflict in the circuits, which is the usual marker for a case that's worthy of the Supreme Court's attention, the court, not surprisingly, agreed to hear the case. Argument took place in January 2016. By the end of the argument, it was perfectly clear that Abood would be overturned by a vote of 5-4. Justice Alito, we can assume, received the assignment from Chief Justice Roberts to write the majority opinion. He no doubt turned quickly to that welcome task, finally achieving what he had set out so deliberately to accomplish. Then, the next month, shockingly, Justice Scalia died. There would be no majority opinion, not this time. By a 4-4 vote, the justices affirmed the Ninth Circuit in a one-line order without further discussion or explanation, and as you may know, a tie vote at the Supreme Court automatically affirms the lower court opinion without precedential weight. It's as if the case never reached the court. Justice Alito would have to wait just a little bit longer, but not very long. Justice Gorsuch joined the court in April 2017. The National Right to Work Legal Defense Fund filed its cert petition in Janus that June. The court granted the petition on its opening day order list at the start of the 2017 term. So who is Janus, Mark Janus? He didn't start out as the plaintiff in this case. The first plaintiff was the newly elected Illinois governor, Bruce Rauner, who, by the way, was defeated in November for re-election, but setting that aside. He was a Republican who had run for office on an anti-union platform backed by millions of dollars in contributions from an Illinois businessman, Richard Uihlein, who also helps fund the Federalist Society, the National Right to Work Legal Defense Fund, the Liberty Justice Center, and a whole raft of other such organizations. With the state legislature controlled by Democrats, Governor Rauner could make no headway with legislation abolishing the agency shop, a step that is open to states, and one that, in fact, more than half the states have taken. The agency shop existed in, I think, only 22 states. So the governor turned to the courts. But his lawsuit was dismissed because, the district court declared, the governor himself had no standing. Mark Janus, an Illinois state employee, was permitted to intervene as the new plaintiff, which is kind of strange in itself because there was no longer an existing lawsuit in which to intervene. But no matter, the case, Friedrichs Redux, was soon on its way to the Supreme Court. The hurdle that Justice Alito and his 5-member majority had to overcome, of course, was stare decisis. And we've all heard a lot about stare decisis in recent Supreme Court confirmation hearings, so I don't need to explain adherence to precedent. Here was a decision more than 4 decades old that had been reaffirmed many times. What to do? Justice Alito did something quite remarkable. He cited himself to show that any reliance interest that attached to Abood had been erased by his own dicta. Listen, Alito, quote, public sector unions have been on notice for years regarding this court's misgivings about Abood. In Knox, decided in 2012, we described Abood as a First Amendment anomaly. 2 years later in Harris, we were asked to overrule Abood, and while we found it unnecessary to take that step, we cataloged Abood's many weaknesses. Justice Alito went on to describe the fate of the Friedrichs case, deriving from the tie vote the implication, and there should really be no implication from a tie vote, the implication that the end of Abood was at hand. Quote, during this period of time, Any public sector union seeking an agency fee provision in a collective bargaining agreement must have understood that the constitutionality of such a provision was uncertain, unquote. In her dissenting opinion, Justice Kagan, familiar to this venue certainly, called Justice Alito out, referring to the court's 6-year campaign to reverse Abood and observing that the majority had found no exceptional or special reason for doing so. Quote, "It has overruled Abood because it wanted to," unquote. She continued, "The majority has chosen the winners by turning the First Amendment into a sword and using it against workaday economic and regulatory policy. The First Amendment was meant for better things," unquote. I've delved at this length into the history of the Janus litigation to make clear the aggressive nature of the court's attack on the status quo, a status quo anchored in democratic accountability. As I mentioned, states have been free from the beginning to adopt the agency fee system for their public employee unions or to reject it. Governor Rauner lacked the political power to accomplish this goal by legislation, so he enlisted a friendly Supreme Court. The disjunction between the court's decision last June and the public mood, I think, is worth noting. A Gallup poll conducted in early August, about a month after the court's ruling, showed public support for labor unions at a 15-year high, 62%. School teachers in red as well as blue states have staged successful strikes for higher pay and better working conditions. To be sure, the fortunes of organized labor have ebbed and flowed throughout U.S. history, in the courts as well as in politics. Now we have entered an era where anti-union forces that can't prevail in politics will take refuge in the courts. That's a problem for the legitimacy of the courts, to be sure. But my point here is a deeper one. What we're seeing in the Supreme Court's recent behavior is, as I framed this lecture, a threat to the foundations of civil society. Earlier in this talk, I asked you to keep in mind Justice Douglas's phrase, as quoted by Justice Stewart, "the furtherance of a common cause." Stepping back from what Janus tells us about labor law or the First Amendment, I think its primary injury is to further constitutionalize the notion that we as a society are not, in fact, united in a common cause, that we can help ourselves to an opt-out of our choice, that we're not all in this together. There's been much talk about the rise of tribalism in the United States and elsewhere. We retreat to our living rooms where alternate visions of reality greet us from across the airwaves, from cable connections and the internet. It's increasingly hard to sustain the structures of civil society under these conditions. The Supreme Court once had an insight, as embodied by Abood and the cases that followed it until recent years, that while we may disagree with another, we're all playing by the same rules. And that's no longer true. When did it stop being true? It's not really possible to pinpoint a moment, but it was certainly well before the 2016 election. The story of the Religious Freedom Restoration Act is instructive. Congress passed that law known as RFRA to reject the Supreme Court's 1990 decision in a case called Employment Division against Smith. In Smith, by a vote of 5-4 and with a majority opinion by Justice Scalia, held that the Free Exercise Clause does not offer a religious exemption from a law of general applicability. That case arose when the state of Oregon refused employment benefits to 2 members of the Native American Church who had been fired for using peyote in a religious ritual. Oregon's position was that people who become unemployed through violating a criminal statute were not entitled to benefits. The plaintiffs claimed a right to benefits under the First Amendment's Free Exercise Clause. Writing for the majority, Justice Scalia acknowledged that the men's claim was a sympathetic one, that Oregon might well have chosen to accommodate, as he noticed other states had done in similar circumstances. However, he concluded, quote, "But to say that a non-discriminatory religious practice exemption is permitted, or even that it is desirable, is not to say that it's constitutionally required, and that the appropriate occasions for its creation can be discerned by courts. It may fairly be said that leaving accommodation to the political process will place at a relative disadvantage those religious practices that are not widely engaged in, but that unavoidable consequence of democratic government must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of all religious beliefs," unquote. This decision outraged religious communities across the spectrum from the most liberal to the most orthodox. The result was the Religious Freedom Restoration Act passed in 1993. And just to give you an example of how broad the coalition was, its chief sponsor in the House of Representatives, where it passed unanimously, was Representative Chuck Schumer, then in the House. In the Senate, where it passed by a vote of 97-3, the chief sponsor was Senator Ted Kennedy. President Clinton signed it into law. RFRA provides that, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unquote, unless the government demonstrates that the policy or practice serves a, quote, compelling governmental interest by the least restrictive means. What amounts to a substantial burden, and by what test? How are courts to evaluate whether a challenged policy imposes the least possible burden on religious adherents? Is every religious claim equally weighty? What does the Establishment Clause have to say about this hypervigilant protection of free exercise? These questions went unanswered. In fact, they were scarcely raised. But Justice Scalia's warning has come to pass. The political context in which RFRA was deployed changed dramatically during the following 2 decades. What its sponsors intended as a shield to protect minority religions has become instead a sword in the hands of powerful forces representing the religious right and the Catholic Church. What we have now is indeed a statute that permits, one might say encourages, in Justice Scalia's words, quote, every conscience to be a law unto itself. The Supreme Court's Hobby Lobby decision from 2014 is really a case in point. The owner of a chain of craft stores with thousands of employees around the country claimed that under RFRA, he was entitled to an exemption from the Affordable Care Act's requirement to include contraception coverage in his employee health insurance plan. He raised a religious objection to certain forms of birth control that he deemed incorrectly to be, quote, abortifacients. In an opinion by Justice Alito, the court held by a vote of 5-4 that the owner of this for-profit business was entitled to the same accommodation the Obama administration was offering to religiously affiliated nonprofits. And by the way, churches themselves were completely exempt from the contraception mandate. These religiously affiliated nonprofits had received the option of informing the federal government of their objection to contraception coverage, at which point the government would notify the organization's third-party insurers to pick up the cost directly. In other words, hands off. The court in Hobby Lobby held by a vote of 5-4 that the existence of this accommodation demonstrated that there was a less restrictive means within the meaning of RFRA to address the employer's religious concerns while still assuring coverage for those employees who did not share his objections. It's important to underscore exactly what the claim was, both here and in the cases that have followed. Obviously, nobody was forcing the Hobby Lobby owner, or in subsequent litigation, the Little Sisters of the Poor, an order of nuns whose chain of nursing homes both employs and serves non-adherents, to buy or use birth control for themselves. Rather, the claim was one of complicity in the sin to be committed by third parties, what Douglas Niejaim and Reva Siegel call complicity-based conscience claims. There are 2 points to note about the nature and consequences of this type of conscience claim as it has evolved. One is the increasingly attenuated nature of these claims. You probably remember Kim Davis, the Kentucky county clerk, who acted under what she called God's authority when she refused to perform her duty of issuing marriage licenses to same-sex couples. That was a straightforward complicity claim. My signature will enable your marriage. The claims put forward in the months and years following Hobby Lobby were much more attenuated. Some employers have asserted that submitting the opt-out form, the accommodation, the opt-out form to the government made them complicit, while others objected to a proposed workaround by which the government would act to assure contraception coverage even without any formal notice. Just anything that makes the delivery of contraception possible, no matter how remote. On this logic, it's difficult to say where the chain of complicity would end. It's hard to see why an employer could not claim complicity in sin when issuing a paycheck that an employee might predictably use to buy birth control products. The second point to note is the scant regard that the conscience claimants and the court pay to the harm suffered by third parties from recognition of this kind of complicity claim. Well, in the Hobby Lobby opinion, Justice Alito offered the view that the decision's effect on female employees seeking contraception coverage, quote, would be precisely zero under the accommodation that the court identified. That has proven not to be the case, as claimants have objected one accommodation after another. As Professors Nijem and Siegel point out, accommodation of such claims, quote, does not entail costs borne by society as a whole. Instead, accommodation has consequences for the third parties whose conduct is at issue, unquote. This became clear in the masterpiece Cakeshop case, in which a same-sex couple left a bake shop empty-handed after the owner informed that his religious objection to same-sex marriage made him unable to bake a cake to be used in celebrating their marriage. In other words, the owner of a public accommodation, legally bound under Colorado law not to discriminate on the basis of sexual orientation, claimed the conscience-driven right to be able to pick and choose his customers. The court decided that case in a way that sidestepped the main issue, but other cases are in the pipeline and will multiply in recognition that the Supreme Court may have an open door. The Trump administration is now testing the boundaries of complicity-based conscience claims with a newly promulgated rule, which I mentioned at the beginning, that permits employers to refuse to cover contraception on the basis not only of religious objections, but of, quote, sincerely held moral convictions. Judge Beadlestone, granting the injunction that I referred to at the beginning, marveled at the new rule's remarkable breadth and asked, quote, who determines whether the expressed moral reason is sincere or not, or for that matter, whether it falls within the bounds of morality or is merely a preference choice, unquote. The administration, she observed, quote, has conjured up a world where a government entity is empowered to impose its own version of morality on each one of us, and that cannot be right, unquote. And that cannot be civil society as we have understood it. That case, too, will predictably come to the Supreme Court. It may seem a stretch to draw a line from Janus to wedding cakes to birth control, but I think all the cases I mentioned present a similar challenge to the Supreme Court and to us. Will the Roberts Court further accelerate the tribalizing of America? Or will this fractured court somehow find a way to invoke constitutional principles that help to hold us together, all passengers on the same boat in stormy seas? Quote, a democratic society cannot flourish if its citizens merely pursue their own narrow interests, the political philosopher Robert Audi wrote 20 years ago. And yet the atomistic First Amendment that the court appears committed to delivering is enshrining pursuit of narrow personal interests as a constitutional right. Recall that Illinois, through its elected representatives, was perfectly free to abolish the agency fee system for its public sector unions, but the will of the people, as expressed through the legislature, was otherwise. It was only in that realization that the governor turned to the courts to do his work for him. Civil society, by definition, exists outside the formal structures of government. Judith Shklar defines citizenship in part as having, quote, a sense of the social environment, an internalized part of a democratic order that relies on the self-direction and responsibility of its citizens rather than on their mere obedience. But neither does civil society exist apart from government, which has the power through law to regulate the structures that sustain it. The Supreme Court, in its role as Republican schoolmaster, in Robert Dahl's classic phrase, is an indispensable partner in the ongoing project of translating into operative law the values that vie for dominance at a given cultural moment. When the court moves from understanding the First Amendment as furthering a common cause to enlisting it as a tool that individuals can invoke to free themselves from the bonds of joint enterprise, something important has changed, and I would argue that something important has been lost. I'll conclude with a brief discussion of recent Supreme Court decisions that deal directly with citizenship and that are disturbing in a different but related way. Decisions dealing with voting rights. These cases can be said to represent really the other side of the same coin, not the individual right to opt out of the bonds of citizenship, but rather a claim to inclusion, to a right that ought to be taken for granted at this stage in the history of our democracy, but that is under sustained attack. The right to vote has an important, indeed an all-embracing symbolic as well as practical dimension. The This is not the occasion to explore in depth the controversy over Republican-driven efforts to raise the barriers to access to the polls through, for example, requiring very precise forms of voter identification. While elderly people, poor people, and members of ethnic minorities are less likely to have or to obtain easily. The Supreme Court dealt in an unfortunately superficial manner with the voter ID question more than a decade ago, when it rejected a facial challenge to one of the earliest such efforts in a case from Indiana. The later 5-4 decision in Shelby County against Holder, disabling the protective apparatus of Section 5 of the Voting Rights Act of 1965, invites a deeper exploration than I can give it here. Suffice it to say that this was an act of extreme judicial aggression, given that Section 5 had recently been reauthorized by large bipartisan majorities of both houses of Congress. In 2013, the Republican-led North Carolina legislature enacted one of the most comprehensive of the newly popular vote suppression statutes. The Fourth Circuit declared that law unconstitutional, with Judge Diana Motz writing for the court that the law had been passed with discriminatory intent and reflected an effort, quote, to target African Americans with almost surgical precision, unquote. The Supreme Court denied the state's petition for review. In a separate, quote, statement respecting the denial of certiorari, unquote, Chief Justice Roberts spoke with evident regret about why the court had deemed itself unable to grant the state's petition. Shortly after the state filed its petition, he explained, a new governor and attorney general, both Democrats, took office. The attorney general moved to dismiss the then pending petition. The General Assembly, still controlled by Republicans, objected and moved to intervene in order to defend the law and appeal the Fourth Circuit decision. The question of who had authority to speak for the state was looming without a readily apparent answer. This is what the Chief Justice concluded after describing this ongoing confusion. Quote, given the blizzard of filings over who is and who is not authorized to seek review in this court under North Carolina law, it is important to recall our frequent admonition that, quote, the denial of a writ of certiorari imports no expression of opinion upon the merits of the case, unquote. So you might have to be a little bit law-trained to understand the gratuitous and revealing nature of that statement. Everybody knows, the courts knows that a denial of cert, a denial of review conveys no opinion on the merits. He's simply saying unmistakably, this is my translation of his jargon, I wish we could have gotten our hands on this case, but the political mess in the state makes that impossible. By no means, however, should anyone suppose that we approve of the Fourth Circuit's invalidation of this law. Last month, Democrats in the House of Representatives, U.S. House of Representatives, introduced a bill they called the For the People Act of 2019, designed to increase this country's notoriously low voter participation by, among other measures, permitting same-day registration and making Election Day a federal holiday. Senator Mitch McConnell, Republican of Kentucky, and the Senate Majority Leader took to the Senate floor to denounce the bill. He called it a, quote, power grab. Making it easier to vote is a power grab. That's the point to which the culture wars have brought us. Will the Supreme Court permit itself to be enlisted as a combatant in the cause of protecting voting rights or of enabling voter suppression? In the answer to that and to the other questions that I've raised in this talk lies the future not only of civil society, but of democracy itself. Thank you very much.
Thank you. Thank you so much. So we have time for questions. A question, just to remind you, is a brief statement with a question mark at the end. I'm going to pose a little bit of social engineering here. First, any undergraduates who have a question? Any graduate or professional school students who have a question?
I guess I answered all the questions.
Linda, you are so extraordinarily clear that the only people who you've confused are the faculty. Okay. Does anyone else have a question? Yeah.
I'm wondering if there's another way you could slice the cases that you were talking about and a lot more, and that is the Supreme Court seems to be siding with the powerful and against the powerless in drastic contrast to the Warren Court. Can you see things that way as well?
That's a frame that one could use. Right. But I think once you say that, then what's the next sentence? So I guess, the way I get into this in linking these cases that I think haven't been much linked in the public discourse is maybe a more generative way of framing them. But if you'd like to write an article just saying that, I'd read it. So, thank you.
Yes. You could pass this down. That'd be great.
So thanks. I'm interested in what you think is how has this come about? So it's partly a question about the politics of court nominations and approvals. Many of these people were confirmed by Democrats as well as Republicans, if I'm not mistaken. Is this just a matter of a convergence of judicial philosophies, a kind of random convergence of philosophy, or are there what might be described as material circumstances which are supporting this right-wing turn on the part of the court? You mentioned financial interests supporting some of this litigation. What else is going on that's pushing, whereas there's a democratic turn in a more pluralistic society, I would suggest that there's this opposite direction on the part of the court?
Yeah, I mean, the fate of the Religious Freedom Restoration Act, I think, is such a fascinating and sort of underexplored, under-theorized story. I mean, somebody will do it one of these years, I guess. But how this law when Employment Division against Smith came down, and I remember this very well because I was in Washington at the time, it seemed to me at the time the opinion made an awful lot of sense. And I didn't always think Justice Scalia was right, but I thought he was right. But I was a tiny minority. And there was a panic sort of across the spectrum of, oh my God, we have to do something about this. And so the court passed this law designed to overturn the court, which those of us who know anything about separation of powers is a very squishy thing to do. And I won't get into the constitutional fate of it. So, it was basically had a liberal impetus. The ACLU was strongly behind it. I mean, every good person on the left you ever heard of was behind it, along with people on the other side. And within 20 years, it's become a tool of achieving dominance by those who are invoking it, basically a Christian majority. And my colleague, Reva Siegel calls a flip like that preservation through transformation. So the majority presents itself as the beleaguered minority and claims, minority protection. So is there money behind that? Yes. Have justices been put on the Supreme Court with an eye to their religious orientation? This is not the most polite thing to talk about. It's hard to talk about. But why are a majority of justices on the Supreme Court today Roman Catholic? It's because they were put there to fulfill the Republican presidential platform promise that any Republican president will name justices who will overturn Roe against Wade. And so you might say civil society, as I framed it here, is collateral damage because RFRA has become a tool to empower those who want to desecularize our society, our pluralistic society. So, you know, it's a variety of things converging in really a very interesting way.
Yeah.
So it seems like the conservative justices seem empowered. How do you explain the ruling in Masterpiece Bakery using a type of technicality rather than making a fundamental decision?
So in Masterpiece Cakeshop, what the court didn't get to the real issue. What it found was that a member of the Colorado Civil Rights Commission, that was the first line of review over the claim in this case, was nasty to the baker and spoke in a way that minimized his religious claim. And so Justice Kennedy wrote for the court, this shows that there was religious bias, and so we're going to vacate the lower court decision and send it back on that ground. That was a real cop-out. I mean, not only, as Justice Ginsburg points out in her separate opinion, this one speaker who said religion, I think the commissioner said something like, we know throughout history that religion has been invoked as a cause of oppression. Well, sorry, I mean, that's history, but anyway, you can't say things like that. That Justice Ginsburg points out, that was one out of 7 individuals in 3 layers of review that dealt with this case. So the notion that the ultimate judgment against the baker was invalid because of that is just as fatuous on his face. But I think the court was kind of stuck, maybe 4 + 4 + Kennedy in the middle. And so it was a way of punting. With Justice Kennedy gone, I don't think they'll be stuck in that way again. I think we may have seen the end of 4 + 4 + Justice X. So I think that's the answer to that.
Thank you very much. So what's to be done? And particularly by whom? By civil society, within the judiciary, within the broader law profession? What do you see as the potential levers of averting this train wreck?
So I think one thing is for people to talk about these cases in an open way that links them all together. I think there's we're afraid to talk about religion and to talk about religious claims. It's really regarded as not very polite. I mean, look at what happened a few months ago, maybe a year ago, when a Trump judicial nominee, Amy Coney Barrett, was up for the Seventh Circuit. She was a professor at Notre Dame who had written from the point of view of Catholic doctrine, and Senator Feinstein had the nerve to question her about the extent to which she'd be able to put her religious preferences aside in approaching cases before the court. And that was regarded as outrageous transgression of politeness by Senator Feinstein, who to this day is being excoriated in the conservative blogosphere for this. And it's elevated now Judge Barrett to like the front rank of the next Supreme Court nominee by the Trump administration. So, we're like afraid to take this on. And that it just enables the continuation of these trends. So that's one thing. The other thing, I mean, There's no quick answer. It's taken a long time to get to this point. It's going to take a long time to undo it to the extent that it can be undone. It has got to be by voting and intentionality. And, you know, our politics determines who sits on our courts. And I sure don't have a quick fix. Wait.
I have a complete easy answer to this problem. Just kidding.
When talking to the mic?
Oh, I was so impressed by Jeffrey Toobin's book, The Nine, where he talks about the conservative effort to pack the Supreme Court and what a longstanding and really persistent effort this has been. But pair that also with some evidence now that the abortion issue was deliberately chosen as red meat to get conservative voters up in arms about the Supreme Court.
Oh, totally. I wrote a book about that.
Right. So what I think, first of all, Democratic voters tend not to care as much about the courts. So the whole thing about Merrick Garland last year, Merrick, by the way, was a classmate of mine. The whole thing about Merrick was not as much import to Democrats and independents as it was to Republicans.
Correct.
So Scalia dying in the end sort of helped get Trump elected. So first of all, Democrats deciding the courts are really important, voting on that, and independents voting on that point, but also perhaps finding sort of the alternative issue to abortion that would get Democratic and independent voters.
Okay, I should ask you what the question is.
What the issue is to get that would compel Democratic voters.
How can we compel Democratic voters to pay attention? Yes. You know, I mean, with due respect to Lester Kissel, I'm not a guru, but you know, maybe what's happened in the last year or so will be a wake-up call. I mean, I can't explain why Democrats. I could explain, but I couldn't deeply understand why Democrats sat on their hands about the issue involving the court in 2016. You know, our politics are our politics.
I wonder whether you're being too kind to the court by
That's not what I expected, Charles.
Rather abstract political science, political philosophy notion of civil society. This is not a conservative court, it's a reactionary court, and it is a terrible use of the word conservative. But is it not correct that if you look at the decisions you've discussed, some of them disable majorities, some of them endorse majorities? And what is it that explains when the court endorses, when it disables a majority, if the result is a reactionary result? Isn't it just that simple?
I'm thinking, because I greatly respect your views and the path that you've traveled since you used to argue before the court. I guess I would just hate to think that's all it is, because that's really depressing. And it would leave those of us who try to deal with these developments kind of with not a whole lot more to say. But well, maybe you're right. It's just, they're just doing what they want to do. As Elena said in her dissent in Janus, you've done it because you could, period. I mean, she went on at some greater length. She offered some legal analysis, but maybe that was the money quote from her multi-page dissent. So yeah, I think we have to keep that in mind.
So I have a question that maybe
Oh,
just...
wait, I think there's one over there. Or,
Oh,
okay.
overruled. Yes, please.
So what, if anything, can we say to inspire faith in the next generation in the rule of law, which is losing faith, ironically, quickly. Do we need to speak at least as often about what the court might be doing right, even if it's small, as we criticize it for what it's doing wrong? And do you see things that it's doing right that we can point to say this is how it's supposed to work?
Well, no. I mean, I don't think sugarcoating the, dire diagnosis is the way to go. So, I teach law students, and I've noticed this year a measurably more cynical, attitude toward the court than I have in the past. So your initial observation is certainly correct. I think it's not so much, well, here's a few things the court's doing right, but help students understand why it's so important that they, as young adults, are embarking on, a full adulthood of American citizenship in which their duty is to do what they can to sustain the rule of law, and not to leave it in the hands of somebody else and not let it slip away.
Professor Allen?
Thank you for a terrific lecture. It was really, really wonderful. You used the phrase that the direction of the court is to desecularize our pluralistic society. That's a way of capturing, in some, the challenge to civil society that we're living through or experiencing. It's a helpful phrase because I think it's probably a phrase the folks on the other side would agree with. That is, they are trying to desecularize our pluralistic society. They would affirmatively endorse that, I think. So the question is, Arthur, in introducing you, invoked you as the person who has helped him understand the separation clause, the question of church and state. I think we are probably living through a time where our basic ways of thinking about the relationship between religion and politics are under pressure. We have habitually had a kind of binary contrast between a secularized world or a sort of religious-sized world. Is there any third way that would permit a new path forward?
Well, I think, the classic free exercise cases before the court got onto the track it's on now, I think most of us could agree, were the right answers to allow, the directly affected individual to say, I need an accommodation here. As in fact, in the Affordable Care Act contraception mandate, the Obama administration, without any prompting or prodding, obviously, granted a full accommodation to churches and what would have seemed to be a very workable accommodation to religiously affiliated nonprofits. You could even debate. I'm a total Establishment Clause person, so I might debate things that others wouldn't. I'm very much with Justice Douglas's dissent in the Yoder case. The Yoder case was the Amish case about, they didn't have to send their children through to compulsory education to the age of 16 because their belief was that would make their children unfit to continue living in Amish society. And Justice Douglas, I think the sole dissenter in the case, said, what about the interests of the children? Who's speaking for their interests? But the court overlooked that because Warren Burger was in love with the Amish because they were law-abiding, whatever. So, I think I understand what the court did there, but I think it's problematic. these cases are really hard. But you know, I think for quite a long time, our system had reached a certain settlement, a certain notion of accommodation, and it's been yanked off that track to something quite different. And it kind of sounds the same until you penetrate it and look at the third-party harm and look at the attenuated nature of the claims. And that's what I'm trying to do here, is say it looks like the same old stuff. We all respect the right of conscience. Without the right of conscience, you know, we would not be having a civil society. But look at the nature of these claims and decide whether you think this is really the way we want to go.
So if civil society is faced with a court that is going to be conservative or more conservative or reactionary for a generation or more, I'd just be interested in your views on one possible solution that seems to have a very small minority behind it, which would be court packing.
If I understood the question, is what do I think of the so-called court packing as a remedy for what we've got now? Well, it's highly theoretical, for one thing. You know, unless you had a Democratic president and a supermajority of Democrats in the Senate, like we can't even think of that. You know, I don't think that's the way to go because it's tit for tat. And so when the worm turns again, you go from 11 justices to 13, and then you go, you know, you'd have 50 people crowded into the Supreme Court by the end of that. So I don't have a quick fix. I mean, it's a very frustrating, I mean, wherever I go, even when I'm not trying to talk about the court, but I just like show up somewhere, people come up to me and I got into an argument the other day, like after a movie, some guy came up to me and said, well, what can we do about this? And I said, well, we have to vote, we have to get mobile. Well, that won't help. What can we do about this? I said, well, I mean, he said, don't you care? I said, yes, I care. He said, aren't you worried? I said, yeah, I'm really worried, and now I'm going to dinner because I don't have an answer to the, you know, all the questions you all are asking. So.
Thank you. Thank you very much for a great talk. Just to take that a stage further, what can we do about this? You know, if the majority feels like this is not right, you're arguing that we should raise the issue and just make it more of an electoral issue. But the deck is stacked against us. You know, the majority vote doesn't decide who's president. The majority vote for the Supreme Court is decided by senators who are very different in the number of people they represent. So there's no way that the majority is really represented in the political decision-making. I'm wondering if there's an alternative that the majority can somehow institute petitions to change the Constitution, where we could actually change the way that the Supreme Court people are appointed, where they'd be appointed by the House and not the Senate or something. Or look at least putting some changes in the Constitution that make it pretty clear that individual rights can't be extended to organizations so easily, and that deal with other things as well. But do you see a method that we could change things by making a constitutional amendment happen? And do you think that could be more effective than just waiting to try and elect different representatives?
Well, I think the way you just phrased the question shows the peril that would lie in that direction, assuming it could even be done. You know, it's really hard to amend the Constitution. But when you said, you know, change the way the justices are appointed and, you know, overturn Citizens United was your implication, of throw in the kitchen sink. I mean, that's a really dangerous thing. So, yes, theoretically, everything can be amended, except I believe, Charles would tell me if I'm right, the amendment process itself cannot be amended, and the 2 senators for every state, regardless of population, cannot be changed. That's part of the basic understanding. Everything else is up for grabs. But when you need 2/3 of each House of Congress and 3/4 of the state legislatures. It's really hard, and it's got to reflect, a real consensus, and it can be exceedingly polarizing. Look at the history of the Equal Rights Amendment. But it can also be a wake-up call for people, and it can have, even if it doesn't pass, it can have other kind, if people feel that way, I'd say try it, but it's probably not going to work.
Thank you so much for your lecture. We have a group of 5 scholars from Kazakhstan who are here.
Speak up a little.
We have a group of 5 scholars from Kazakhstan who are here to research, conducting research on ethics and governance. And they are themselves from the country which is still building its civil society and its court system. So in your research, first of all, have you had precedent cases from outside of the United States that could have been imported or have helped you in prescribing your solutions? And the success cases, can they be exported and adopted to other governments, and to which extent?
Okay, insofar as I understand the question, I'm not sure I did understand the question, but are there any things that any lessons we can take from other? Yeah.
More successful civil societies.
Well,
Can we export our
So, one thing that's interesting is that the various emerging democracies that have taken cues from us in their newish constitutions and setting up constitutional court systems, none of them have chosen to give life tenure to their high court judges, not a single one. We are the only country in the world that has life tenure for federal judges, and in fact, every state has a judicial system, and of the 50 states, only Rhode Island has life tenure for its state high court judges. Everybody else in the world has a term of years or an age limit. So you might say our system has been found unappealing to people in modern times who've given this some thought. So, some people say we ought to take a crack at it here, either by constitutional amendment, which is the obvious way because life tenure is hardwired into Article 3 of the Constitution, or by a statutory workaround that other people have proposed. And I think that's a good conversation to have. But, I think a lot of our judicial problems are a reflection of our politics. So, there are some, so in Germany, as I understand it, it requires a supermajority in the legislature to confirm the appointment of high court judges, and that means that you have to go to the middle, and you're not going to go to the extremes. Getting rid of the filibuster, as the Republicans in the Senate did in the following President Trump's election, left them free to go to the extremes. So, there are fail-safe mechanisms that can be put in. That could be put in kind of easily, I think, through the filibuster. It's just a matter of Senate rules, how many votes it takes to confirm. The Constitution doesn't say anything about that with respect to judicial confirmation. So, we certainly have lessons we can learn from other countries, that's for sure.
Hi. In thinking about the range of cases that you reviewed, sorry.
Okay.
In thinking about the range of cases you reviewed and putting aside the commercial speech cases, a lot of them seem to turn on either LGBTQ issues, abortion, or birth control. And I'm wondering if you might adequately describe what you're describing might be characterized not simply as an opt-out from civil society, but an opt-out for a particular set of issues that have a particular constituency within the Republican Party. Because, simultaneously, the same court is likely to affirm the ability of state-level majorities to prevent people from opting out, let's say, on abortion rights. So the court's kind of doing both things, right? It's making it easier for people with the values of the religious right to opt out of statutes of general applicability, but it's also making it easier for state-level majorities where the Christian right has influence to impose requirements on people who might otherwise want to opt out. So I'm wondering if that explains a lot of what you're doing rather than the general fabric of opting out of civil society.
Well, I mean, the reason I started with and spent such a big proportion of the talk on the labor case is I actually do think it transcends the hot button social issues and the whole First Amendment. What's happening with the First Amendment, I think, is very indicative of that. So, I mean, taking your point, but I wouldn't want to just limit our concern to LGBT and abortion, because I think it's bigger than that. I think that's a manifestation of it, but it's not the definition of it.
Thank you, Professor. I was wondering, in your time as a court reporter, what evidence you had found that Catholic ideology versus political or judicial philosophy had influenced the justices' decisions in respect to these cases?
Well, certainly later abortion decisions. For sure. Gonzalez against Carhart, the so-called partial birth abortion case, was just a kind of a rant of personal revulsion on the part of the 5-member majority against abortion. It didn't have any legal analysis in it. I think a case called Town of Greece from about 4 years ago, in which was a challenge to practice by a town council of having prayer to open their town council meetings, and the prayers were delivered by the local clergy, all of whom were Christian clergy, and many of whom invoked Jesus and over religious doctrine and blessing the meeting that was about to occur. This was challenged, and the challenge was upheld in the lower court. The Supreme Court reversed 5-4, the usual 5, the usual 4, saying Justice Kennedy wrote it and said, we all have to put up a speech that we don't like occasionally, and this is just one of those times, and if you don't like to hear the prayers, well, don't listen. I mean, I'm boiling it down a little, but basically that was the analysis. And, Justice Kagan raised a few red flags about that and got into a kind of peeing contest with Justice Alito inside the frame of that opinion. And it really came down to, I think, one's sensitivity toward the pluralism of our society. The majority just didn't recognize it as a problem. So, is that directly from Catholic doctrine? I could hardly stand here and say that was, but it reflected an insensitivity by the majority to other claims.
Thank you. So I was curious about your decision to include Masterpiece in the fold of these cases that bring out the opting out of civil society, because to me that seems more like not an opting out of civil society, but a very clear decision to discriminate, which to me seems like a step further, perhaps. So do you see opting out of civil society as something that brings with it discrimination, or is discrimination in that case to you not really the issue?
Well, no, I really see it as kind of the same thing as the other cases, because Colorado has a law on the books that says if you're running a public accommodation, which is defined as, among other things, a retail, operation, you may not discriminate on the basis of, sex, race, and sexual orientation. And this baker says, well, that can't apply to me because I have a religious claim. So he's asking for an exemption. He's asking to be able to opt out at his say-so. And, if you take the new Trump rule on the contraception mandate, where you don't even have to claim a religious objection, you can basically say, I just don't feel like it. That's the line that we're walking.
So we have time for one, and if we're quick about it, perhaps two more questions. Wait for the mic.
I've got Louis Son.
Talk into the mic, please. Talk into the mic. Mic in your mouth. Yeah.
Son taught here at Harvard Law some decades ago. He World Peace Through World Law is the key book. Were he here, he would be saying, let's look at the world out there. Let's look at international law, international treaties. We seem to be stymied within a particular nation state. But it might be more profitable, more helpful, especially in a world where global solutions to the environment, to nuclear weapons, have to come about, that we ought to be taking the Son lead and considering at least international alternatives.
Okay.
There's agreement there. One last question? Well, I'm sorry.
I'll just open it. I'll ask it as a quick sort of open-ended question.
Wait, I can't hear you.
Sorry. Do you have a theory about why the Supreme Court has become such a site of political contestation in the United States? So I'm from Canada. We have a Supreme Court.
I'm jealous.
I can tell you that probably most Canadians, including most educated Canadians, can't name a single Supreme Court justice in Canada or a controversial Supreme Court decision in Canada. And so can you help me understand, why is it so controversial here and not where I come from?
So, I love Canada. I've interacted with many Canadian judges. Some of my best friends are Canadian judges. It is a mystery. But I think part of the reason is, of course, your charter's pretty new. I mean, it's 30 years, something? So, there's not an impulse to go back and say, what did this mean in 1789? You just have to understand what the consensus was in 1985 or whenever it was. I mean, it's a different frame. But also, so you don't have the tradition in Canada, as I understand it, of politicians who can't get what they want through politics trying to get it through the courts. And that was the titanic battle over President Reagan's nomination of Robert Bork in 1987. The Reagan administration was sort of fading out. The Democrats had taken control of the Senate. The Reagan administration, which had had great hopes for getting control of the courts and the Constitution, was realizing it couldn't do that. And so put this guy on the court and do it that way. It didn't work. It's been an overt place of contestation through our political culture in a way that you have been spared, and you were very lucky.
One question after the last question.
So this was a masterful lecture, first of all. Thank you very much. And mine is just a sort of a quibble, really, about this idea of, atomization that the court, that you see the court as pursuing through its decisions. But then a lot of the objections that you raise against these decisions have to do with their, the ways in which they stifle pluralism, in favor of a majority religion, in favor of excluding racial minorities from the political process. And so that seems much less like atomization and much more like imposing a certain idea of civil society at the expense of a more democratic and pluralistic one that's friendlier to diversity. If they were so concerned, if atomization, if a sort of libertarianism was driving these decisions, for example, we might expect them to be friendlier to a woman's right to choose, because that's atomization, right?
No, that's interesting. I'll have to think about that. That's a fair point.
So it is not by a vote of 5-4, but it is unanimous. This was illuminating and a masterpiece, but had nothing to do with.
Okay, thank you.